Hello everyone, and welcome to our Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. Today's is Farm It, Develop It or Produce Energy on It, how to maximise the opportunities from your land. Next slide please. And my name is David Rayner. I'm a partner in the Agriculture and Estates team, and I'm head of the Burkitt Long Environment and Energy team. As you can tell from my grey hairs, I've been doing this for a long time, and that has the benefit that actually I've been recognised in the independent client guides, the Legal 500 and Chambers directory as being an expert in my field. Unfortunately, it's my field and not yours, but hopefully you'll feel that you can refer any questions to me, and I'd be very happy to work with you on any projects that we can assist you with. I'll take questions at the end, so please do make use of the Q&A facility. Next slide, please. So the agenda for today is farm it, let it, develop it, produce energy on it. We'll then go to questions, as I've said, and then we'll give you details on how to get in touch with us. Next slide, please. I have to stress that this information in this presentation is for general purposes only. It doesn't constitute advice. This information is correct as at today and is subject to legislative changes. Next slide. So if we're talking about farming it, what might you be doing? Well, particularly because this talk is about diversification, you might want to think about crop diversification. And there are some interesting ones that potentially you could be doing that are being done elsewhere in Essex. Pumpkins, for example, or we have a very successful wine industry in Essex now. So you might want to look at vines if you've got the appropriate aspect and the appropriate soil for those. Legumes might also be something that you want to look at, or flowers and fruit, because of course, as sustainability keeps moving up everybody's agenda, if we can grow them here in Essex, that will cut down air miles and therefore assist with sustainability. You might, in addition, want to let parts of your land or some of your buildings out. You might want to use some of your land for leisure and tourism businesses, or you might want to create a business, learning or other hub on your land. Of course, in Essex, we have an enormous pressure on our land for the various uses that it could be. We have some very good quality farming land, which needs to be farmed. We also have pressure from housing development, the infrastructure that goes with it, or other projects, and of course for energy. Next slide, please. Sorry. So if you are diversifying, if you want to let out part of your land, or more likely some of your buildings, how might you do that? There are various ways, and this slide shows you the possibilities. You could just grant someone a license. The risks with that are that if they have exclusive occupation, they will almost certainly be held by a court to actually have a lease. And if they have a lease and it's a lease of business premises, then they may well acquire protection under the 1954 Landlord and Tenant Act. If you want a short-term arrangement, you might think about granting them a tenancy at will. That, of course, is perfectly feasible. It doesn't get protection under the 54 Act, but the risks for you are that, of course, it is literally at will, so the tenant could leave at any time. The far greater risks, I guess, are for them because you could terminate it at any time. So that may well not be acceptable. And really the best solution is to have a short form lease that is excluded from the 54 Act, so that when it comes to an end, they have to go. If you let them in early, there are some risks, as I say, not least because if they have exclusive occupation, they may claim early rights. If you let them in early, there may be a disincentive on them to actually complete the lease that you want them to take. At the other end of it, if they don't leave on time, then we will obviously have to look at possession proceedings, and we have a very good property litigation team here who could assist you with that. The only other area here that I wanted to mention was telecoms, and of course, as I'm sure those of you who have any telecoms masts, aerials or other structures on your land will know, not only do the telecoms operators potentially have protection under the 54 Act, but they also have protection under the telecoms or the electronic communications code, which gives them very, very significant rights. And of course, those rights have recently been improved because the government wants to improve connectivity around the country. Next slide, please. If we're talking about a lease, the things you need to consider when discussing those with a potential occupier, and that we will then document for you, are how long is it going to be? What's the level of rent that you are going to charge? Will it be an inclusive rent so that perhaps you continue to pay the rates rather than passing that on to the tenant? Depending on the length of the lease term, you may want to have rent reviews. You may want to have break rights included, either for you, for the tenant, or mutual rights. Who's going to insure the buildings? I'd suggest that is certainly best to have you as the landlord insuring, and then recovering any insurance premiums from the tenant, or as I've said already, you may want to have an inclusive rent. Will there be a service charge? What rights is this tenant going to have? Will they have to come over an access road, use of a yard, perhaps communal toilets? All of those things will be services that you are providing should you be recovering a percentage of those from the tenant. Will you want them to carry out any alterations? I'd suggest that you certainly don't want them to carry out structural alterations, but you may be happy to let them do internal non-structural works, probably with your consent not to be unreasonably withheld. How about them disposing of that lease? Can they just transfer it to anyone? Can they sublet it to anyone? Again, I'd suggest that they can't do that without your consent not to be unreasonably withheld, and there are very standard provisions that everyone is aware of and would expect to see included in any lease. What's the actual use that they're going to be putting the property to? You need to think about that, you need to define it, and you probably want to restrict it to that specific use or any similar use within the same use class. How might you want to end it? Specifically, you will want to be able to forfeit this lease if the tenant is in arrears with their rent, if they breach any of their obligations in the lease, or if they become insolvent. Other usual provisions that you would expect to see in a lease, the big one is repair. Depending on what you're actually letting to them, that might be an internal only demise, in which case they're only responsible for the interior, or they may be responsible for far more, but repair is an essential clause to have in the lease, and with that comes decorating. And depending on what you've let to them, if it's office space, you may want them to replace the floor coverings at the end of the term, for example. There'll also be obligations on the tenant to comply with legislation, so that, for example, if fire escape legislation changes, energy performance legislation changes, you will want them to comply with that. And you will also want to have a right for the landlord to enter the property at any time on notice and without notice on him in emergencies, just to check that they are complying with their obligations. And if this is a part of your larger farm area, then to make sure that you can actually carry out any works to the rest of your land. You may also want to think, depending on how good this tenant is, whether you need a guarantor or a rent deposit from them, I'd suggest that in the current climate, guarantors are maybe no stronger than the tenants, and that it's probably always preferable to take a rent deposit so that at least you can get your hands on some money, even if you can't recover all of the lost costs that you might suffer. Next slide, please. If you're wanting to develop some of your land, then does the land have development potential? Is it in the local plan? There are quite a few local authorities in Essex where they do not currently have a 5-year supply of land, and accordingly there is a great opportunity, but it will be a limited window and a window that is closing to make applications for residential development on your land. Who should be in your team? Well, obviously a lawyer to document what is agreed. You'll also need to have a land agent, and the land agent will certainly be able to advise you on the planning prospects and negotiate heads of terms for you that the lawyers will then document. I've seen heads of terms that range from about 4 lines on one side of a piece of paper to ones that can range up to 20 pages. Detail is important, but it's also important not to spend all the time negotiating the heads of terms and no time negotiating the legal documents that follow from them. We work with all of the significant land agents in the county and the region. We get on very well with them, and they know us and we know them and how each operate. The other person you'll obviously need is also an accountant or perhaps more specifically a tax advisor, particularly on capital gains tax and potentially on VAT as well. Next slide, please. If we're talking about developing the land, the possible structures that you might have are set out on this slide. So you may have a conditional contract. So you find someone who wants to develop the land and they will say, that's great, we'll go ahead, we'll apply for planning, and if we get a planning permission that we're happy with, we'll then buy the land from you. So the contract will be conditional on them getting a satisfactory planning permission. It's important in that documentation to really tie down what a satisfactory planning permission means. The developer, of course, will want it to be as wide as possible. You will want it to be as tight as possible, because once they get that satisfactory planning permission, they will have to buy the land. When they exchange the contract, they'll pay a deposit. It'll probably be a nominal one at first, but they may have to make that up to 10% of the potential purchase price once they get planning. You'll also want to have a long stop date in that contract so that it can't go on and on forever. An alternative to a conditional contract is an option. These are more normal than conditional contracts. The thing that I have to stress to you about them is that even if the developer gets planning permission and it's absolutely fantastic, does exactly what they want, they are not bound to buy the land. They have an option to buy and they have to exercise that option, and they may not do so. Certainly during the early parts of the last recession, a number of developers were getting out of options even though they had good planning permissions. You'll want to have a method of calculating the purchase price, and of course the developer will want to be deducting as many of its costs as possible, so all of the planning costs, all of its investigation costs, dealing with any contamination and such like on the land will be deducted if they can possibly get them as deductions. But as I say, options are very popular. Another alternative is a promotion agreement. The difference here is that you will be entering into agreement with a promoter, and there are many promoters around. Some are more aggressive than others. They will take your land through planning. They will incur all the costs of doing that, and they will pay you a promotion fee for you entering into the agreement. Once they've got planning, They will then market the property and hopefully get a developer on board, and at that point you will negotiate a sale of the land to that developer. There will be various provisions in the promotion agreement, and I'll come on to these in a minute, about the relationship between the promoter and you. The big selling point that promoters always make is that your and their interests are aligned, and by and large they are, whereas in an option, you and the developer's interests are not aligned. They will be looking to get as much of their expenditure deducted from the price that they're paying, whereas the promoter, of course, is wanting to get the best planning permission they can get to maximise the net developable area of your land, to maximise the price that can be obtained, and to keep infrastructure and other costs down as much as possible. Where I always tell clients the interests are not quite so aligned is that once the promoter has got planning permission, they will then almost certainly want to get a sale agreed as quickly as possible, whereas you may not want to sell either quickly or to the first person who comes along. So at that point, we need to make sure that what is in the promotion agreement covers the position adequately, and normally it will be a sale or disposal strategy that needs to be agreed between you and the promoter, and this is where you will rely very heavily on your land agent to negotiate and agree that and liaise between you and the promoter. A preemption agreement is not seen so frequently, but basically it's a right of first refusal that you might give to a developer or your neighbour, that if you decide to sell your land, they will get a right of first refusal. Next slide, please. So having gone through the 4 possible ways of documenting a disposal for development, here's a slide that sets out some common themes. The obligations that are likely to be placed on you. First of all, to act with the developer or the promoter to obtain a satisfactory planning permission. Secondly, and most importantly, to give vacant possession of the land when a sale arrives. It's very important that you understand that you will have to be able to give vacant possession at completion of a sale. That means that if you've got any tenants or occupiers, they have to be off the land by the time that sale arrives. There will usually be an obligation on you not to make any competing planning application. And there are various others that will deal with how we get from exchange of the document to completion. The developers and the promoters' obligations obviously are going to be to take the land through planning, obtain a planning permission, and then if it's a promotion agreement, to find a buyer. As I've said already, you will be relying heavily on your land agent to keep a check on what the promoter is doing or what the developer is doing through the planning process, and to also keep an eye on the costs that they are running up, and that they'll be looking to deduct or take from the price at the end of it. The promoter will be paid a promotion fee on completion of the sale to an end developer. That promotion fee, they will charge VAT on it, and therefore if we're talking about a promotion agreement, it is usual but not always the case for landowners to look to elect their land for VAT purposes so that you can charge VAT and so that you can recover any VAT that you have to pay to the promoter, and also any VAT on your costs. Disposals. You may want to have a provision in there protecting your ability to dispose of the land even while the option or the promotion agreement is continuing. Certainly, depending on what the family arrangements are, I will try to put a clause in so that you can dispose of the land either to new trustees if the land is held on trust, or to members of your family or people connected with your family without the consent of the promoter or the developer. If you transfer to anyone else, they will want to have to give consent to that, consent not to be unreasonably withheld, but they will say that you mustn't dispose of it to anyone else who might be a developer. Don't think that's unreasonable. You will probably want this to be personal to the developer or the promoter that you've entered into this documentation with, because you are relying on them, you've checked them out, and you've probably built a decent relationship with them. So you will not want them to be able to dispose of it to anyone else, except perhaps other companies within the same group of companies. Once you've exchanged an option agreement or a promotion agreement, you need to be aware that the developer or the promoter will protect their rights under that agreement by registering an entry against your land title at the land registry, and that will be obvious to everyone. There will invariably be time extensions in any option or promotion agreement to enable a planning process that's already running to come to its end, whether that's with the grant of planning permission or going to appeal or fighting any judicial review proceedings that might be brought by third parties who are objecting to the planning permission being granted. So we have to get to the end of any potential challenge period to any planning permission. However, you will want, and the others will want as well, to have a sensible long stop date in there to give those proceedings time to expire. You'll want to be able to terminate this if the promoter or the developer goes bust. You may also want to be able to terminate the agreement if they are in a material breach of their obligations. They won't like that because, of course, at that stage they probably have incurred significant expenditure, and that's a question of negotiating with them. As I've already said, they'll be looking to deduct all of their costs if it's an option agreement, or deduct them before the proceeds are split between you and them if it's a promotion agreement. There will also be provisions relating to planning agreements. Section 106 planning agreements or highways agreements are the usual ones. You will, of course, be the landowner at this stage, because they will need to be entered into to get the planning permission that then triggers the sale or the exercise of the option. And we will always put in provisions that protect you so that you don't have any liability until the planning permission has actually been implemented, or, for example, and if you dispose of your interest in the land, that your liability immediately ceases. And we will certainly put in provisions so that you are indemnified fully by the promoter or the developer. There will be provisions about community infrastructure levy, which obviously many councils or local authorities now have, and the obligation to pay that will be put on the developer or the promoter. There will need to be a provision in there about dispute resolution. Hopefully there won't be disputes, but if there are, the normal way to deal with them is to go to an independent expert. There will also be provisions about both parties acting in good faith and that you're not actually forming a partnership, because that will have significant adverse tax consequences if the revenue decide actually you are a partnership. I always also like to see provisions saying that you as the landowner cannot be deemed to be a developer, again because of tax provisions. Next slide, please. So if you're not developing it, you might want to think about producing energy on it, and there are various ways of producing renewable energy these days. Obviously, solar for photovoltaic is the one that we all see. There are also wind turbines, although we tend to see those off our coast rather than on land, although I've certainly acted for some farmers and landowners who have granted leases to wind turbine operators. Biomass, heat pumps, anaerobic digestion are other ways of producing renewable energy. If you are looking at sustainability generally, you might also want to look at how you can stop waste of energy on your farm, because too many people think about creating renewable energy and don't think about the other side of the coin, which is stopping wastage. That can have a very significant impact on your bottom line if you're able to just become more environmentally friendly and sustainable. Next slide, please. So if we're going down the renewable energy route, what will normally happen is that you'll either enter into an option or a conditional contract with the solar panel operator or the wind turbine operator. Apologies, because they won't obviously want to take a lease of the land until they've actually got planning permission to do what they want to do. So we would negotiate the terms of those and the eventual lease that would be granted to them. All the points that I've made previously about option agreements and conditional contracts come into play here. And again, I must stress that if it's an option, they don't have to exercise it, even if they get an acceptable planning permission. You may well also be asked to enter into a power purchase agreement if you are going to be taking some or all of the power that is being generated. Again, that is something that we can negotiate on your behalf. The two big issues that will delay matters are planning and getting a grid connection. I've seen a number of proposals fall away because the grid connection is too far away to make it feasible or viable, and or the power network operator is just not prepared to countenance the connection that the developer would like to have. On planning, and actually this applies both for renewable energy projects and for housing development, I think it's important for you to appreciate that you as the landowner, even if the planning application is made by the developer, or more likely it's made in joint names of the developer and yourselves, you as the people on the ground will be the people who the neighbours, the objectors, see as being the landowners, and you will be the people who get the hassle and the objections. So you just need to bear that in mind before you embark on any of these projects. Linked to this, there may well need to be additional rights being granted to the energy operator, rights of way, or possibly running cables or water. Nowadays, of course, panels and turbines are operated remotely, so these sort of connections are absolutely vital to them, and also having a means of communicating with the panel or the turbine. Again, I always like to make sure that that's fine, but they can't have a telecoms mast on your land for the reasons that I've already mentioned. And there will be various covenants that are imposed on them to make sure that they're operating the equipment properly and generating the electricity required, and also on you, so that you can't interfere with what they are doing. So for example, if it's a solar panel farm particularly, they won't want trees overhanging, shadowing the panels. And if you don't trim them back, they'll want to be able to come on and do that. I had one a farmer who was actually granting an option and a potential lease to a turbine operator, and who didn't like the obligation that they were putting on him not to run any chutes where the members of the chute could fire across the turbines that were going to be put up, A, because they didn't want the turbines being peppered with shot, and B, because they were worried about their employees and the responsibility they had to them. And this particular farmer actually felt that the income that was generated from his chute was of greater value to him than the income that could be generated under the turbine lease. And so that matter, in the end, almost didn't go ahead until we were able to reach compromise on how that was going to be split between them. Next slide, please. So there may be other opportunities that you want to consider in the sustainability renewable field. Storage of electricity or power is, of course, becoming ever more important, as with the technology for the solar panels and the turbines. The costs are coming down, they're becoming much more affordable, and the technology is also improving. I'm certainly dealing with a number of transactions where we're looking to grant battery space or gas holder space to operators. You possibly might want to consider rewilding or sequestering carbon on your land, or even entering into conservation covenants, which of course is the coming thing. You may have timber or forestry on your land that could be used in renewable energy projects. How could we document that for you? There are other more, perhaps at this stage, esoteric ideas of having indoor farming. I'm sure many of you will have seen the proposals that Wilkins, the jam factory at Tiptree, have already put in, improving the way they grow their strawberries in their greenhouses on a raised bed. But there are other possibilities for growing crops indoors, for farming indoors. There may be opportunities for meat production. I'm sure we've all seen the press reports that belching and farting cows are contributors to greenhouse gas emissions. I said that in a previous talk, and someone then emailed in and said, rubbish, cows are not the cause of the climate emergency. And of course they're not, and I didn't say that, but they are a contributor, and there are all sorts of wonderful ways of trying to control what they do and the emissions that they produce. However, the big point, and I don't know who's listening, but if any of you are livestock farmers, is that actually the quality of the meat that we produce and the quality of our herds here mean that actually they produce less emissions than the poorer quality animals and the food that they eat in third world countries. And therefore we have a lot to gain. We have a lot to say about what we're producing, how we produce it, the emissions that leads to, and we can encourage others to follow our lead. Definitely esoteric is the mini livestock and future foods idea, where you might want to be farming insects and creepy crawlies, and why not? Or of course you may be able to enter into agreements with the Environment Agency or the local authorities, depending on where you're located, in respect of flood defences. All of those are linked to the sustainability agenda that you might want to think about, and where we can help you. So next slide, please. So before I take any questions, We will be sending a recording around to everyone that signed up to today's webinar, and that will come out to you tomorrow morning. We'll also include a link to a very short feedback survey, and we'd really appreciate it if you could complete that so we can make sure that our future webinars are helpful for you. And obviously, if you say nice things about me, the usual $5 will be in the post. I said at the start that this is one in a series of Wednesday webinars. Our next webinar is, despite what it says on that slide, because there's been a slight adjustment, our next webinar is an employment law update, which will be on the 9th of March. If you're interested in our future webinars, please visit our website or our Eventbrite page to sign up. And now I will take any questions if you have them, but thank you very much.
Thank you, David. The first question that we have is, I have some fears that we might be able to get some planning on for residential development. What do you think is better, an option or a promotion agreement?
Okay, thank you. Well, as I said, it is a bit of a horses for courses point, but at the moment, we're definitely seeing far more promotion agreements being entered into than option agreements. As I also said, the ideals that you and the promoter will have are much more aligned, and you will be working together more than if you enter into an option agreement where really you and the developer are on opposite sides. So you may feel that going for a promotion agreement is preferable. Either way, you won't be incurring costs, planning costs, or legal or agents costs, because those will be met by the developer or the promoter. They will of course recover those down the line when a sale actually happens, but you don't have the cash flow problem now. Thank you.
Thank you. The next question we have is, I've had a car restorer in one of my spare barns for several years now. He pays me an agreed amount each month, which is what we're happy with. Is this really a problem?
Well, the answer is probably yes. As I said when I was talking about letting out some of your barns or other buildings, the issue is that they will have acquired some rights. They will probably have got exclusive occupation of the area that you've let them into. They're paying you an amount. You haven't documented it, so that if it's a lease, there could be some implied lease terms that you may not like. And I would strongly urge you to get it documented properly, because there will come a time when you want to get them out or they want to leave, and that needs to be covered and you need to be protected. So I know it's an easy thing to say, just keep going as you are. I'm afraid that I've seen too many farms, and I've done an awful lot of marina work as well, and in a way that they're fairly similar, where a lot of occupiers get let in. It's all on an informal basis, and then when the going gets tough or there's a falling out, the solids really hit the air conditioning. So I do urge you to get it documented properly.
Thank you very much, David. That's all the questions that we have for today. Okay,
well, in that case, just remains for me to thank you all very much for joining. I hope you found it useful. And obviously, if you do have any questions, please send them in and we will deal with them after the event. And if we can assist you in any way, please do get in touch. My contact details are on the slide. Thank you all very much, and goodbye.